We're on the record in the matter of Credit Acceptance Corp. versus Erica Brown, file number 23-00187 GC. Counsel appearance.
Good afternoon, Your Honor. Lynn Olivier, attorney on behalf of plaintiff.
Okay, Ms. Brown is present via Zoom. Ms. Brown, do you have an attorney? You're muted.
I do not, but I would like one though.
Okay, well, if you would like an attorney, then you're going to need to hire an attorney.
Okay, so do I go through legal aid for one or something for a case like this?
You could reach out to legal aid and like see if they have the capacity to assist you in this matter, but you would be responsible for seeking your own legal counsel on this, okay?
Okay.
Okay, but today was the date and the time set for a pretrial on a general civil proceeding. Counsel, did you all come to a joint pretrial statement on this?
No, we did not discuss it. I'm sorry. But a scheduling order would be preferred today.
I'm sorry?
And if would like a scheduling order entered today.
Okay, well, I need your joint pretrial statement in order to do that.
Okay.
Were they advised of that when you put them in the private meeting room? No, but they need to complete a joint pretrial statement.
Can we go back in a breakout room?
What's a pretrial statement or?
Okay, we're gonna send Attorney Olivier, we're gonna send you an email with our form that needs to be completed. That's what we use to kick out our scheduling order, okay?
Okay.
You have our email? Okay, can you provide us your email, please?
Lynn.Olivier at rvolaw.com.
You're both already in room 1. You just need to return to breakout room 1. Thank you. On the record, the matter of PCA acquisitions versus Jeffrey Kinney. This is file number 23-00309 GC. Counsel appearance.
Good afternoon, Your Honor. I'm perhaps opposing counsel is not.
I am. There's a slight rendering delay. It just takes a couple of seconds when I hit the buttons to turn the camera and the microphone back on.
Sounds good.
Good afternoon, Your Honor. Michael Bankstein, P69778 on behalf of Cavalry SPD1.
Good afternoon, Your Honor. Diana Sagararis, P32106 on behalf of the defendant, Jeffrey Kinney.
Thank you. Today was the date and the time set for a pretrial on a general civil matter. Did the parties either come to a joint pretrial statement or a resolution of this matter?
We have not reached a resolution, but we're going to do a joint pretrial statement.
Okay. Did you have our standard form or are you going to enter your own form?
We could use the standard form if opposing counsel is not opposed to that.
That would be no problem.
Can we have your email, please?
I'll spell it out letter for letter because there's a lot of like sounding consonants in my name. M as in Mike, B as in boy, E as in Edward, N as in Nelson, K as in kite, S as in Sam, T as in Tom, E as in Edward, I as in ice, N as in Nelson, at stillmanlaw.com.
Okay, that'll be over to you. And once you all complete that, you can just file that with the court. That will kick off your scheduling order. Our civil clerk's department will send you a scheduling order based on that, okay?
Thank you, Your Honor.
Sounds good, Your Honor.
No problem. God bless you. Any additional matters that you want to address while you're here today?
I have nothing further, Your Honor.
Nothing further from defendant.
Thank you. You're all set for today.
Thank you, Judge.
No problem. We're on the record in the matter of ADL Consultants LLC versus Andres Castro, file number 22-02995 LT. Counsel appearance.
Yes, Chris Brown representing plaintiff.
Mr. Castro, do you have an attorney?
I do not, Your Honor.
Okay, today was the date and the time that was set for a pretrial. I'm very unclear as to why this was set as a pretrial. I do see a letter in the file. It looks like you sent a letter in dated March 28, 2023, which was date stamped received by the court March 30th, 2023. Is that correct, Mr. Castro?
Yes, Your Honor.
It appears that the letter serves to describe some issues that you had with the property.
Yes, Your Honor. I just wanted to get on the record saying that I disputed what was found in the motion that was filed against me in the summons.
You dispute what, sir?
Well, so in what I was provided, it just goes along to say that I had left certain things broken, that I had caused certain damage to the domicile, and that was not the case. I just think that if they can go ahead and put something like this in the court, which was just untrue, and that's what they're filing, I wanted to make sure that I had my word involved.
Okay. So this is a matter in which the plaintiff, were you rented or resided at the address of 3621 Lowcroft, is that correct?
Yes, Your Honor.
Okay, and so it looks like there was an eviction for
Well, I
non-payment of
moved
rent
out.
that was filed. Excuse me?
I'm sorry. I'm sorry. I didn't mean to interrupt.
Thank you. There was an eviction for non-payment of rent that was filed back in September 2022. This matter having stated that you were served by posting because they could not, after diligent efforts, make contact with you at the address in which you were, I guess, renting at the time. Did you move off the property and not notify anybody?
Well, it was done via email shortly after I left. Yes.
You vacated the property via email and you notified whom?
The email, there was an email address. I believe it's Garno Property Management. I have it in my email inbox, or probably in my sent items.
Okay, when did you email them that you had vacated the property?
Probably about a month or so after I had left.
Okay, when was that? As I need a date.
Let me see. Give me just one moment, Your Honor. Let's see here. Okay, it was back in the end of September. Yeah, September 22nd, it looks like.
Okay, so you vacated after the eviction had started, correct?
So I was out of the house. I never got it. I lived at my dad's house.
I gave a very direct
I'm
question.
sorry. Yes,
You
I
vacated
guess.
after the eviction was started because I have a demand for possession for non-payment of rent that says you were served September 2nd.
See, I wasn't served. I didn't get anything until later when somebody came to my house and gave it to me.
Okay, the demand for possession was served by first class to the address 3621 Lowcroft. You just indicated on the record that you had not vacated. So it was served to the address that you still.
Oh,
that you
yeah, I
still
didn't
held
live
over.
there. I moved into the new house on September 1st. Yeah, I
Okay,
didn't
but
live
you-
at,
You still were receiving mail at this address though.
no, I wasn't. I shouldn't have
Yeah,
been.
if you didn't move out, if you didn't move into a new house until the day after that you were served, you still received mail there, sir.
No, I was September 1st that I had moved in and I had filed a change of address.
On what day did you file the change of address?
I'd have to take a look and find, actually, I think I got an email about it too.
Okay, send that email plus the email that you noticed them that you had vacated the property and an updated address whereby you could be contacted. Send that to Judge Simmons' courtroom at lansingmi.gov and I'll get it right now.
Hold on, give me, let me find that. Email change of address. Sort of back in. Oh, come on, USPS. There we are, US, no, that's not right. No, that's not right. This says that it was at the beginning of November, but I wasn't getting mail there. I wasn't living there. I wasn't there.
No, send me what you got. We're not gonna dispute what you got.
Right, yeah. No, it shows September or November 1st. One moment. Let's see here. So. It's Judge Simmons' courtroom.
At lansingmi.gov.
lansingmi.gov. Okay. I just sent that, but I have a copy of the new lease agreement that I've signed also.
I'm not interested in that.
Well, that would show the date that I moved in the house.
I'm not concerned about the date that you moved out of the house. I'm concerned about when you notified them that you vacated the house. And I'm also concerned about when you changed your address with the postal service. That's what I'm concerned about right now.
Yeah, hold on a second. What is this, folks?
No, just for it. Okay, you didn't change your address until November 1st.
Right, but that's when I got the email from the post office. I had submitted it before that. I know I
No,
had.
order submission, start forwarding date November 1st. So that means your mail will still go into this address to that time.
But
where's the email where you notified them that you had vacated the property?
I just sent it through.
Yes, please. Okay, as of September 22nd, you had not even turned the keys over. So you still, you knew or had reason to know that you had been served with an eviction at the time that you vacated the property, but you never responded. You never appeared in court. You had a failure to appear back on December 21st, 2022. We gave you a courtesy after you didn't appear, and we reset it, giving you another option to appear in January, to which you still failed to appear. Hold your
Had no
tongue,
clue.
don't talk over me. I saw it coming. To which you still failed to appear. It is now well beyond the statutory time frame whereby you can request to have a default judgment set aside. Even if you were within that time frame, per the court rules, your requirement is to provide me with meritorious defense and good cause. You need to give me a good cause why you missed court or why you should not be defaulted, and a meritorious defense to the underlying case. But only thing you provided me so far, and this is based on the information you shared, was that you vacated the property and changed your forwarding address after the time in which you had been served with an eviction. Mr. Brown.
Thank you. Request a default be entered for non-appearance based on the testimony herein. Thank you.
Thank you. Mr. Castro, I'm not sure what your letter serves to do. Is it just to put the court on notice of these things, but you've missed, you're well beyond the time frame to even respond in this case. And my court records show that you were served. There's a certification here for September 2nd, 2022, first class mail addressed to the person in possession of the property of 3621 Lowcroft. That was served and filed with the court. When that was also served, even before you vacated, which there was an email as of September 22nd, I have here your complaint. So there was a notice to quit for September 2nd. Then there was a complaint September 10th. And that complaint was served after multiple attempts by attachment, and then a mailing of first class mail. So the court doesn't have anything to believe before me to make me believe that you did not get properly served under the law. Mr. Castro, you can unmute yourself.
I don't have any, I mean, I know what happened, but everything that you said is true. So whatever I know and whatever they know doesn't really matter. So I'm not going to win this argument. Congratulations, Mr. Brown.
Okay. The fault was already entered, I believe. Let me double check. It should have, because of. Okay, default here before the file default judgment in the amount of damages of $1,873.02 plus $190.67 for costs, and attorney fee, which is statutory, of $75 for a total amount of $2,138.69 is entered by default because there was never an appearance within the statutory time frame by you, Mr. Castro. Okay.
Okay.
Now, as to any claims that you're making in your letter, because I wasn't sure if this was to be construed as an answer that was just late or a counterclaim. To the extent that it was your intention to file a counterclaim, your best course of action at this time will just to be to file a claim against them directly for those things. Okay, sir?
Yes, ma'am.
Okay, do you have any questions for the court at this time?
Nope. Can I leave? No, please. Let's leave.
You're free. Yep, you're free to go. Thank you. Thank you, Mr. Brown.
Thank you, Your Honor. Thank you.
Thank you. Ms. Olivier, was somebody else in the waiting room or breakout room? Let me bring them in. Just bring one for me.
And it's Teresa's.
Olivier, were you able to complete that?
Yes, and I emailed it back to the people that sent it to me.
Okay. Did you need this put on the record at all, ma'am?
Not as far as I'm concerned.
No,
Okay, just a moment. And Ms. Olivier and Ms. Brown, judge signed this, so you all are all set for today.
Thank you so much. I assume copies will be coming in the mail.
Yeah, the civil department will send out a scheduling order. Yes, ma'am.
Okay, thank you so much. Have a good day.
thank you. Bye-bye.